So welcome everyone to our e-mobility on legal obligations, which Mathieu Quenin has kindly agreed to present his thoughts on the subject from Capsticks. I'll let him tell you a bit more about himself in a moment, and also Jan Taranchuk is also going to be on the panel, along myself. We're going to knock around a few ideas and then welcome, obviously, questions from you guys, the audience. Matthew, it's over to you, please.
Thanks very much, Nigel. Hi, everyone. Thank you for joining this session today. So as Nigel said, my name is Mathieu Quenin, which is very French and very difficult to pronounce, even for me. So by all means, do feel free to call me Matt, which will be much easier. So you'll have noticed from this really funny accent that I originally qualified from another country, not too far from the UK, although fear not, I have fully requalified as a solicitor, specializing in construction litigation with a focus on building safety, and in particular, all the developments that there have been following the Grenfell Tower inquiry and the associated legislation relating to the BSA, and obviously all the subsequent regulations that stem from the BSA. So today, very happy to be conducting a session on e-mobility devices. So yes, e-mobility, landlords' legal obligations, which is going to be the subject of my presentation, our presentation today, and obviously the questions that will follow. So in terms of contents, please don't worry, it won't be too long. There are 20 slides in total, but I'll make sure that I keep the content as entertaining as possible. So first, we'll see that there's been a growing risk regarding e-mobility devices over the past few years, and very much of a focus clearly over at least the past 5 years. It is a risk which is specific now to landlords, because for some of you as landlords, you will be responsible given the stages that you have under the legislation that I will cover. So that's why you do need to be proactive, either by anticipating, so preventing risks before they occur, or by mitigating those risks once they have occurred. So I'll be covering all of those elements through this presentation. And by all means, if you have any questions, please do feel free to pop them into the Q&A so that we are able to answer afterwards. So as you all know, lithium-ion battery-related incidents have been hitting the headlines in recent years. So whether we are talking about exploding phones or electric car fires, or indeed, for what is the interest of our topic today, e-bikes and e-scooter that will set ablaze. Something interesting is that abroad, people seem to be more alert to the risk of those batteries. And I'm just going to give you an example. So I so happen to be in Southeast Asia at the moment, and the battery I was traveling with, a small thin battery, was thrown away whilst I was flying through China, out of the risk of the fact that it could provoke an incident. And Chinese people were really not happy. Well, Chinese security and customs were really not happy about the fact that I'd been able to fly with that battery from London to Shenzhen. So that was the first incident of my trip here, and subsequently Vietnam. I bought another battery, which I left in my luggage, quite stupidly, I must say. So not in my carry-on. And I was stopped by the Vietnamese authorities to go and pick up my battery and to make sure that it was traveling with me in my carry-on. So Heathrow, no issue whatsoever with my good old battery, whereas evidently in some other countries, those batteries, the lithium batteries, however small, are fire safety risks that is taken into account. So yes, one of the most concerning features of battery fires is that they can seemingly ignite days or weeks after they were thought to be extinguished. So there is a real risk there, and that's why there have been so many incidents, as a matter of fact. So I should say, as a fire safety sort of expert within my area, construction litigation, and also building safety expert, the focus over the past few years has very much been on cladding and improving building safety in general following the Grenfell disaster. So we had the 7-year-long public inquiry, which concluded last September through a significant report, which was obviously quite damning, as well as the enactment of the Building Safety Act 2022, which is a life-changing primary, a piece of primary legislation for building safety lawyers, given the ramifications that it has for absolutely every single aspect of building safety. And as you'll know, it is bound to change following the Grenfell report and the government's plan of action in that regard. So something to look out for and to see, to see how it will pan out in future. So recently we've had a shift, so a focus from building and improving them, and the fact that now the focus has shifted to things that are brought into those buildings, including e-mobility devices containing those batteries. So in the UK, there are several death fatalities every year in domestic fires caused by lithium-ion batteries. And if we look at London in particular, so only in London, e-bikes and e-scooters cause fires every 2 days, we are told by the London Fire Brigade. And we can see that it's increased exponentially over the past years to reach roughly 150 fires over the past 2 years, only in London. So why is it so important to, for some of you as landlords, to be so aware of those risks? It's because fatalities do occur, and potential liabilities as a result of those fatalities will be borne by landlords. If we consider the recent inquests that there have been in respect of a few recent cases, there have already been 4 inquests because of fatalities related to e-mobility devices in domestic premises, one of which being the Shadwell fire. So that was a fire on Cornwall Street, with the coroner's report that was published in 29th of August 2023, and it was caused by one of those batteries. And what I must say is that basically with all those 4 inquests, we have common findings, which are there are too many fatalities that are caused by e-mobility devices annually across the UK. There is a lack of understanding in relation to the dangers of those batteries. There's no standard at present that regulate how those batteries are made. We'll see that it's going to be regulated fairly soon, but at present there's none. and it is easy for people to buy them and to tamper with them. And so we find ourselves in a situation where we have lots of tenants that have those very incredibly dangerous devices that have been tampered with, sometimes unwittingly because they are not even aware of it. Sometimes they have done that themselves, which is a major risk of fire. And so if we look in particular of the Shadwell fire, this is a case that is of interest because you may be aware that it was the fire occurred in premises where there was over occupancy with very many tenants, and the surviving tenants are now commencing legal proceedings against their landlords based on negligence and liability under the Occupiers Liability Act 1957. So liability is being engaged. I haven't been able to allocate any updates on this case at present. Again, that's something that will be interesting to see what the court decides, and where it goes in terms of liability for landlords going forward. But there is that civil element as well as, and obviously it's beyond the scope of this presentation, but a criminal element. So as landlords, you also want to make sure that you do the right thing to, well, as a matter of principle, but to avoid civil liability as well as potentially criminal liability. I think so. Yes, I was ahead of this slide. So the common findings amongst the coroner's reports, obviously those slides will be circulated to you. So we've been able to identify 4 inquests which have led to interesting findings from the coroners and have elicited responses from the government and other agencies. And so it's become incredibly pressing now for the government to introduce regulations to make sure that those batteries will indeed be subject to a framework so as to ensure that health and safety is safeguarded for all, including tenants. So what you may wish to know, I'll just cover this very briefly. I appreciate there's loads of information in this slide, is that there are some regulations at the moment, although they are not really complied with. I've quoted 3 of them, but manufacturers actually ignore those regulations, mainly because they are located abroad and therefore they are not really subject to them. And so once those batteries are imported, there's actually no regulation and very much of a lack of statutory solution to tackle this issue at present. There is lots of guidance, and you will have come across it. So the reason why I actually set it out in this slide is to show that I think too much guidance is very much killing the purpose of raising awareness, because that guidance is incredibly confusing. It comes from different authorities. None of that guidance none of those pieces of guidance contradict each other. However, it's really difficult at present for you to potentially navigate through that guidance. Personally, personally, whenever asked questions about guidance that should be followed, I have found that the LFB's guidance is the most comprehensive one. So I would suggest that you look at the LFB's guidance. Oddly enough, it is even more comprehensive than the guidance from the NFCC. So I think the LFB's guidance in general is a good first response whenever you have queries about what to do and not to do. So given the urgent need for legislation, have this timeline here, just so you know, regulation is underway, as I was saying. So in August 2023, a product safety review was launched, asking for views on what to do in order to regulate those batteries. In July 2024, the King's Speech confirmed the introduction of a bill intended to reform the UK's product safety regime, including those batteries. September 2024, draft bill was introduced to the House of Lords. November 2024, the Labour government published its response to the initial product safety review. And at present, we are in a sort of a back and forth between the two chambers in relation to this bill, which has still a long way to go before becoming law, but ultimately we will have this product regulation and metrology act, which will regulate those batteries. So something to look forward to. So you may think, well, let's just wait to see what the regulation will say before we actually do anything, even though we are aware that there's a risk that our civil liability and criminal liability may be held, but we don't have any guidance at present. We don't really know what to do. We've got the guidance from the LFB, but that's about it, and there's not much that we can do. Well, actually, you do need to be proactive, and I think that's something that you'll have heard of before. As landlords, very often you will be an entity that has responsibility depending on certain circumstances. So you'll be potentially the responsible person under the Fire Safety Order 2005. I must say, as a fire safety litigator, that is the piece of legislation I come across the most often at present. So the LFB has very much cracked down on landlords recently by issuing notices, mainly enforcement notices against landlords, including housing associations, and those you need to be aware that if you are served with an enforcement notice, you have only 21 days to appeal it, and most of the time you'll need to appeal it because the enforcement notice is just far too ambitious, to put it politely. It won't allow you to comply within the allocated timetable. So if you see enforcement notice, responsible person, that you have found your duties allegedly according to the LFB under the Act, the Fire Safety Order rather, you need to be prompt in appealing it to the magistrates court, and that's something that obviously we are really happy to help with. But that is not the only piece of regulation that may apply. You may also be responsible as the principal accountable person, PAP, under the Building Safety Act, if you are dealing with a higher risk building, so 7 stories, 18 meters. I won't delve into those details, but you'll know whether in your portfolio or your stock, whether you have a HRB, and therefore whether you may be a PAP, a principal accountable person. You'll be aware of the distinction between principal accountable person. If not, what you need to know is that there's always a principal accountable person. If there's only one accountable person, there will be a principal accountable person. It may be a managing agent, although it's not always clear. So if you have a query in that regard, again, we are able to advise because it's quite technical. Most of the time, you'll be the responsible person under the safety order 2005. So it's the first row in the table. If not, you may be a principal accountable person under the Building Safety Act. But you can also potentially be subject to the HSWA, so the Health and Safety at Work, etc. Act 1974, because you do have a general and overarching duty to comply with health and safety regulations. So those three pieces of legislation may all apply at the same time to you as well as managing agents, and they'll be investigated, or rather applied, by different prosecutors. So for the fire safety, the Fire Safety Order 2005, it will be the Fire and Rescue Authority, so LFB in London. For the principal accountable person under the BSA, that will be the Building Safety Regulator, BSR. And for the Health and Safety at Work Act 1974, it will be the Health and Executive. So how to be proactive then, given that you may be the responsible person, the principal accountable person, or responsible. Oh yes, no, something to say before that. You may think, oh well, in that case, let's ban all those devices. Let's ban all those batteries. They are just causing issues. We don't want to have them. Well, no, because the thing is, if you are to do that, you may actually find yourself as indirectly discriminating against your tenants, because they may have disability is a protected characteristic under the Equality Act 2010. So banning all these devices within the premises is not the solution. However, what can be done? So preventively, so for tenancy agreements that are going to be drafted, my housing management colleagues will be really happy to advise you on that and draft those contracts. But you can, for example, ensure that obligations and covenants are included in relation to e-mobility devices, so have specific provisions in those tenancy agreements. A question that you may have is, can we do that for existing tenancy agreements? Not really. You would have to obtain the agreement of the tenant, but I'll just touch upon policies that you can implement, which may prove as effective as having those provisions in tenancy agreements. But so you could also have a provision, for example, that would say no flammable material, whereby you include a covenant that states that no flammable material will be stored in the property, or not to cause nuisance, or for example, item as treated as abandoned, which we'll be able to talk about. But for example, you can include a provision in your tenancy agreement saying, well, if you abandon your e-scooter or your e-mobility device in the common areas, when you know that it's forbidden to have them stored in the common areas, we'll treat them as abandoned, and therefore we'll be able to get rid of them. So that's something that can potentially be introduced in your new tenancy agreements. You can also have a sort of sweeping up / catch-all covenant, which may potentially prove itself incredibly useful, whereby it states that residents should comply with health and safety regulations in general, and that any breach will be sanctioned, and that you will pursue the tenants that are in breach. So tenancy agreements can cater for the risks associated with those devices and the batteries. If not, particularly for existing tenancy agreements, what you may wish to have is to have a policy which is effectively a permission policy whereby all tenants have to ask before being able to store those devices within the premises, within the building. Because in an ideal world, you'd want to have a dedicated storage space that may not be able to postpone, that may not be able to be postponed. But what you may be able to do is on a sort of case by case basis, you may be able to allow one of your tenants to have one of these devices on the basis of the Equality Act, for example, because they are disabled, and that's something that can be discussed with the tenant. I've seen a hand. Shall we just keep the questions for the end? I'm almost done, and I think what we can do is discuss the questions at the end.
Yeah, that's good, Matt.
Yeah, perfect. So yes, the policy could include something about the fact that it complies with the Equality Act. It's clear on its scope, that it is retroactive. That's why it's interesting, because it could apply for all existing tenants, whereby you'd say, this is our policy now, you should be aware of it. And you'd make it clear that, those devices shouldn't be stored in communal areas. Insurance should be taken out by tenants for their devices, and that you will not hesitate to take enforcement actions if they fail to comply. And that flows nicely to what I'm going to talk next, which is what to do once those risks have already arisen. What can you do if you are in a situation where you are aware that a tenant is not complying and has a device in their premises? So there are sort of various scenarios to consider, which will vary depending on who you are as the landlord and the location as to where the items are stored. So if you are a registered provider, the most straightforward way to deal with those breaches is probably the Antisocial Behaviour, Crime and Policing Act 2014, which is quite efficient in providing a route for you to sanction those breaches. So it allows a registered provider, amongst other persons, to seek an injunction from the court saying that tenant did that. Please ask them to either remove their device, provide an order whereby their device will be removed, and then we can do that. So it covers communal areas and private premises. That's why it's quite convenient. And limited evidence is required, as in you only need to show that you have warned your residents on several occasions that they could not store an immobility device, but they have nonetheless persisted in doing that, notwithstanding your warnings. So I think in general, and that's something that I would say as a litigator, just keep records of absolutely all your correspondence, making sure that you have a trail, so that if you need to go to the court to ask for an order, an injunction, you will be able to provide very quickly evidence, including correspondence. So the situation will be different if you're not a registered provider. You still, as a registered provider, you still have those routes, although you may not need to use them. So I've sort of broken down what you can do here in that case. So if the device happens to be in the communal areas, what you may wish to issue is a tort notice. So effectively, what a tort notice is saying this device shouldn't be there. We're notifying you that we won't be held responsible if we remove it. We know that normally we would be committed a trespass to your goods by removing it. However, because we are notifying it that this device shouldn't be there and that therefore we're going to remove it, you are backing yourself up. So that's the purpose of the tort notice. So it's giving a sort of warning, which will then allow you subsequently to potentially remove the device. However, you need to keep the device when you do that. So it may be tricky, but the main benefit of a tort notice is that because it's quite scary and it's a legal route already, it may by itself result in the tenant complying with that and accepting to remove their device. Otherwise, another route that can be explored is to abate a nuisance. So if you do that, you need to evidence that it is a very dangerous nuisance and that you have no choice but to finish it, to get rid of it. And so again, you will need to make sure that you have evidence to be able to back yourself up in order for that route to be available to you. It's potentially more straightforward. You don't need the court authorization for either of those options, tort notices and nuisance abatement. However, you will need legal assistance. But that's the routes that we can explore for you. If the immobility device is in private premises, it's much trickier because in that case you do need to go to court, and there are potentially two options here. So either an order for specific performance, whereby you say, well, according to this lease, to this tenancy agreement, the tenant was not complying with their obligations, and therefore we're asking the court that they are forced to comply with their obligations. But this is provided that the tenancy agreement existed in the first place and indeed catered for that situation and set out those obligations that the tenant couldn't have an immobility device in their premises. A policy wouldn't be able to be used for an order for specific performance here. What may be able to be used is an injunction, whatever the situation, based on the danger that represents such a device. You will need to obtain the court authorization. It's what we call an equitable remedy. So it's at the court's discretion. You really need to show the court that you have no choice but to do that, that the tenant has been incredibly unreasonable, that you've done absolutely everything in your power to be able to ensure compliance with your policy, your tenancy agreement, health and safety in general, and that in spite of all of that, the tenant is still in breach. So you may be able to obtain an injunction. I was speaking to housing management colleagues about injunctions earlier today, and there is a debate at present as to whether forced entry would be granted. It's fairly rare. So it's fairly rare. It does happen, but the court must be absolutely convinced that everything else has been exhausted first. So those are options that we are able to advise you on and can be implemented. There is an additional power if you are an accountable person / principal accountable person under the Building Safety Act 2022. Again, it will be only for high-risk buildings, so 18 meters in height, 7 stories minimum. And so for those buildings, you may be able to implement actions because residents must not create a significant building safety risk. So, for example, improper storage of an e-mobility device. If they do that, you are able to issue a contravention notice. However, the contravention notice itself is not enforceable, as in you don't become the police because you are a principal and accountable person or an accountable person under the BSA. You don't become the judge, the Fire and Rescue Authority, or the HSE. You are a person that has legal duties. You are implementing those duties, and if breaches are still existing, then you can obtain from the court that your notice becomes enforceable. But that is a tool that could be used for higher risk buildings, and this covers all the tools that exist at present for. And I think if you have any questions, we can now discuss them.
Yes, I think so, Matt. Thank you. That's excellent. It's given us lots of things to think about there. Jan, do you want to kick off with some of your questions?
Well, no. Well, I've no need. Some colleagues here, Heidi, Tracy, and have come in with some good questions, as has Leah. And I think some of those that are best addressed by Matthew, so I can tackle. So I'm happy to unusually for me, shut up and let the audience do the speaking, for Matthew to deal with those and for you to pick those up, and I'll come back at the end if that's okay.
No problem. Yeah, good. Thank you. So we've got a question then from John. Is it enough to inform tenants via leaflets and direct meetings about their dangers and their responsibilities? Do you think that's that would be judged a reasonable response, or are there other things that you think we should be doing?
No, there really must be a policy in place. It is the advice that we're giving at present. There must be a policy that is prepared. A meeting wouldn't be enough.
And I have to say I agree. I think the meetings and the leaflets are important, and quite clearly it has to work the other way around, because there's no point having a policy and then people won't necessarily take any notice of it, in the same way they won't necessarily take any notice of the meetings, the meetings and the leaflets, because as we're knowing in London, the fires are still happening and people are turning around and going, I didn't realise, I didn't know. The challenge we've currently got at Minute, colleagues, from a social housing perspective, is the fires that are occurring, we don't actually know whether they're in social housing properties, because this fire brigade doesn't register the tenure of the fire. So whilst all these fires are occurring, we don't actually know for fact whether they are in social housing properties. So I would urge those of you who do have a fire in your property to share that information, because the fire brigade, London Fire Brigade, are about to change the way they collect the information, but it'll take ages. So I think the first thing is the policy needs to be there. Secondly, obviously this is very London centric, and I apologise that the people on the call from across the country, you need to be liaising with your own fire and rescue service, because quite clearly people who turn up with a big red engine and have a big hat have usually taken more notice of them than poor old housing officers. But that joint work with the local brigades is showing promise in various parts of the country, and I would urge you to do it if you haven't already started.
Yeah, thanks, Jan. Yeah, and I'd echo that. I think all the fire and rescue services that I've spoken to, they would welcome, and indeed they are looking for opportunities to be working with landlords and their tenants to actually start addressing these risks. So Leah's asking, where does landlords stand when giving advice on e-scooters, which, as we know, are not legal for use on public road or pavement? Does that actually make any difference for us, Matt, when we're looking at what comes into our building? Well,
no, and also you have to know the limitation of your expertise. So it's what you can regulate is storage of those e-devices. However, you can't start investigating whether those devices are compliant or not compliant in general with the existing regulations, which are limited, as I mentioned. But no, I think it doesn't really change anything. But Jan, if you...
Well, I'll add to that, because those of you who weren't on the call last month with Gen 2, if it's worth going back onto the Metro Saw website, and perhaps Nigel could share the link on this chat. Gen 2 up in Sunderland have done some really good work with the Tyne and Wear Fire and Rescue Service and with a local company in identifying units that were not roadworthy, essentially, and they've worked very closely with the Fire and Rescue Service. So I think all of that together, it's the joint working is really important, and us as housing managers understanding that we don't understand that particular part of the issue. We just need to make sure that what's in our properties can be safe.
Yeah, that's helpful, Ian. Thank you. And that sort of leads into next question from Heidi, I think. So can we remove mobility scooters from inside the property? How would we know if the battery is dangerous? Some defects will be very obvious, as in if they've been modified. A bike conversion kit, for example, you need a bike conversion kit, for example. You can, some of the things are very high risk and easily identified, others less so. I think part of this policy is sort of distinguish, well, what might be acceptable and what might not. But Matt, what's your thought on that?
So are you well, but I think the first question, and it's sort of linked to the question that there is just after, it is the question that you want to ask yourself is, are you okay with having one of the scooters inside the property in the first place? From all the policy documents that I have reviewed, but Jan will be able to have a more of a practical stance. From everything that I've seen, landlords are usually not keen to have those devices within the premises of the tenant, and policies limit that. And so this would be the first question to potentially ask yourself: are you okay with them having their e-devices within their properties? And then I think, as Nigel said, some elements will be very obvious. Some others, well, you won't have the expertise for that. So you may need to regulate for absolutely everything and decide a plan and action for absolutely every single e-device.
I think that's right. And I think, again, I urge people to look at the Gen 2 experience, because there's no point reinventing the wheel, because I think what they've done is excellent. It's also important to remember that not everything electrical on bikes is dangerous, because many bike manufacturers are able to claim and identify they've never had a fire with their kit because it's been built properly in the first place. So I think working closely with Fire and Rescue Service and sharing that information, but also then the information about how to charge the bike, because it may well be that there is nowhere else for that bike to go, and that then becomes an issue. But the challenge then is to ensure that the resident knows that by sticking it on a charger in the socket next to the front door and charging it overnight is probably not a very good idea. And that bit of advice, in my view, is as important as everything else, because it's the charging bit that's the dangerous bit. And I keep saying to people, you can't trust anything electrical these days, and you need to be clear about not charging anything overnight. And that's part of that general advice linked to what the advice is for your local fire and rescue service. Yeah,
that's great. Thank you. So yeah, I think probably answered both questions there. Davi's asking about a nuisance abatement challenge, whether that can that be served by both a housing association as well as a local authority?
I would need to double check that. I would tend to say yes normally, although I would be keen to check. So I think that's something that I can follow up on with my housing management colleagues. But I believe that yes, for local authorities that is possible as well.
Yeah, good. Well, if anyone's got any other questions, feel free to stick your hand up.
So, Nigel, can we just go back to Simon's point, which I think is a very valid one, which is the person-centred fire risk assessment. I think that's a really valuable point, because I think not enough attention is being paid to person-centred fire risk assessments, and I think that they should be undertaken in any event every time a tenant moves into a property, and should be part of the general toolkit for housing officers whenever they're visiting properties, so that we're building up a picture of the fire risks within the property, whether they relate to the individual or they relate to the way that individual is living, and that includes whether they've got an electric bike stored in the corner or whether it's a mobility scooter. I think all of that helps to build up the picture that landlords need to take a greater interest in, because up until now people have tended to say, and it happened with hoarding many years ago, housing managers at a senior level used to say, well, we can't do anything about that because it's behind the front door. And I think if Octavia Hill, the queen of housing management, was around today, she'd be saying it is very much our business and we need to know, and it's something we should be doing.
Yes, that's good, yeah. So please, anybody's got any questions, do stick your hand up, and it'd be great to hear from you. So Paul is making a point there about the danger of, if I understand it rightly, danger of indirect discrimination if we say a scheme is unsuitable for somebody that needs a mobility scooter. Any thoughts around that, Matt, please?
Well, it is a difficult one. It is a difficult one because a disability is a protected characteristic. So as such, there would be a breach of the Equality Act 2010. However, there is an exception when one is able to show that the aim goes beyond that protected characteristic. Sorry, I'm making it really convoluted. If I make it more simple, basically, if you say, well, look, okay, you are disabled, but fire safety takes precedence over your disability, you have an excuse. So that is something, but you need to be absolutely certain that you can discriminate against on that basis, on the basis of that excuse. So again, you may wish to seek legal advice from my discriminatory law colleagues, for example, who will be able to advise.
Can I just add to that, because I think it ties into the original point about person-centred fire risk assessments, because quite clearly, if somebody has that nature of a disability without the mobility scooter, they may well have difficulty escaping from either the building, the home that they're in. So they may have a problem getting away from a fire if a fire occurred in the property itself, or they might then have a difficulty escaping from the building if there is a fire elsewhere in the building. And all of that needs to be taken into account, because the experience so far, and I'm happy to be for somebody to disagree with me, but I'm not aware of a mobility scooter fire occurring inside a property having a problem, because we're back to the charging thing again. Most concerns for local authorities or housing associations has been the concern of a mobility scooter being charged in the corridor and causing both a blockage and potential for smoke. So that's I think the main issue. It's how that individual is dealt with within the property from a general fire safety perspective. And just moving on to that next question there from Tracy, how do we work with leaseholders with mobility issues? It's the not quite sure there, Tracy, whether you're talking about people who are tenants of leaseholders, in which case the responsibility is actually under the RRO, is actually the leaseholder, the person who owns the property the tenant is occupying. It's their responsibility to deal with their tenant, although obviously as the freeholder, we would want to be involved in it as well.
Yeah, that's good, Jan. We've got several points here. I think on mobility scooters, there have been fires in flats, but not very many.
Okay.
And they can potentially take place when when they're not being charged. So both are possible. But I think the thing we can't ignore is that the majority of the fires are happening with e-bikes and e-scooters, but particularly e-bikes that are being modified. So in a sense, and I'm not trying to make light of the challenges around mobility scooters, because they are they're not insignificant, but the biggest risks around e-bikes and that sort of thing are possibly the ones that we should be dealing with, giving them the most urgency and importance, and having a clear path to and very robust process in place to deal with those. And like you say, the mobility scooters, the incidents are pretty infrequent. They could still happen, but they're relatively infrequent. And if you've got a quality product that has been regularly inspected and checked and has not been, modified, the risk is quite low. So just sort of add that to just to sort of give context, I think. Do you think that's a fair?
No, I agree entirely. And Simon's point about it's the adapted e-bikes that are the real concern is absolutely spot on. And that's where Tower Hamlets and Gen2 and Poplar Harker and others have been doing clever things. And I would urge colleagues on the call, if your organisation is doing clever stuff with regard to residents about e-bikes, I'd be interested, because I've been asked by the CIH to lead a session on fire safety up in Liverpool in September, and I'm looking for people to join me on stage to say how clever they've been as to how they're dealing with the residents. If anybody's got a flag to wave to say what they're actually doing in a positive way, please contact me. I'm on LinkedIn. If you're not already connected to me, let's have a conversation. But I think it's the adapted e-bikes is the main issue, and that's where all the attention has been given by fire and rescue services as well.
No, I agree. So we're nearing our wrap up. Matt, would you have any sort of key takeaways? What would you summarise from the discussion that you like people, if they're going to take away, a couple of three things? Remember this, and this. What would you say the key?
Yes, I would say don't rely on the upcoming legislation. Act now preventively. So don't be complacent. We know that it was one of the main critique from the Grenfell Tower inquiry. So act preventively. For your new tenancy agreements, include those provisions that should be there. And for those that already exist, have a policy in place. And yes, and make sure of the role that you have within those premises. But yeah, policy and tenancy agreements are my two takeaways from today.
Absolutely.
That's good, Matt. Thank you for that. Yeah, and what would you?
No, I very wisely, I agree. I agree with the lawyer.
No, that's excellent. Well, what we will be working on, and we said before, please do put out questions, guys, that you would like us to address in future events. I think we'll be exploring that further in terms of, well, what could a policy look like, what should be allowed, and maybe what should definitely not be allowed, and that sort of thing. We're keen to share best practice on that across the industry. So it's been really helpful, Matt. Really appreciate that. It's given some clarity around several aspects in terms of the obligations and potential steps, tools, and things that we can use to address these risks. But I think completely agree with you. It's a significant risk, not one that we can ignore. And like you say, get policies in place. I always think, educate, awareness, start to establish where your risks are and how you can start to reduce them. You can't do everything all at once, but you can make a start. And I think I will put that link in a moment for the last webinar we did with Gen2, and I think that set out a really good way where you can actually start that process off, even though there's definitely going to be a step 2 and a step 3 further down the line. But we can start educating, we can start assessing and uncovering and identifying those risks and starting to mitigate them. So thank you, Matt. Really appreciate that. Thank you, everybody, for joining today. We will circulate recording slides, notes, etc. over the next few days, and look out for the next one. Thank you much, everybody. Have a great day.
Cheers. Well done.
Thanks
Thank
very
you.
much.
Thanks, Matt.
Thank you.
Thank you.
Thank you.